Welcome, everybody. Good to see you guys today. We have a very special guest speaker today, Dr. Brian Farrell from the UI Law School, also president of the Innocence Project of Iowa and a good friend and colleague of mine. And he is going to talk about wrongful convictions, exonerations, criminal law, and all of these kind of things, making a murderer, serial, all of these fun things tie into the work he's done. He has his law degree from the University of Iowa, and he has a PhD as well. Author of a forthcoming book on human rights. And so I will turn it over to him. He's going to do a little presentation, and then we should have plenty of time for questions and answers with you guys. So please welcome Dr. Brian Farrell.
All right. There we go. That's better. So hi, everybody. As Andy said, I have practiced law in Iowa for about 15 years. I'm a graduate of the UI Law School. And about 8 years ago, I helped co-found the Innocence Project of Iowa when I moved back to Iowa. Still involved with that organization as its president. I work over in the College of Law where I run our civic engagement program. I work with the UI Center for Human Rights. And also teach both law and undergraduate human rights courses. And I do a lot of talking on this topic, on wrongful convictions, sort of the phenomenon of wrongful convictions, the causes, and what we do to try to prevent and remedy innocent people who are convicted of crimes they didn't commit. So I'm giving you kind of my general overview that I give for a lot of groups that I talk with, and as you can imagine, the last couple of years, these issues have been much more in the public eye due to things like serial and making a murderer. So I've been talking a lot about this. There are some parts that I will dwell on a little more. Some parts we'll talk through a little more quickly because I also want to take your questions, and I'm happy to talk more generally about the criminal justice system and about criminal justice reform. Sort of the main presentation here, the PowerPoint that I'll go through, is really focused on this issue of wrongful convictions and the science, the data that helps us understand wrongful convictions. Having said that, there are plenty of other things in the criminal justice system that are in need of, I would say, dire attention, reform, and a new approach by us as a society. And just as by way of background, a little more about myself, graduated from law school in 1998. And I practiced here in Iowa for about 6 or 7 years, did private practice work, started doing criminal law work. I'd prosecuted for a short while and discovered I really enjoyed criminal law. As I progressed through that practice, I started doing criminal appeals, so arguing before the Iowa Court of Appeals, the Iowa Supreme Court. I also started doing post-conviction work, which is after somebody's convicted, after they have their appeal, they have an opportunity to essentially have a new trial to challenge their conviction. And so these are trials that take place 5, 6, 8 years after a conviction has occurred, where a person can bring in new evidence to try to challenge their conviction. And so I did a lot of that work. I then followed my wife to Georgia, where she took a teaching job, her first college teaching job in the psychology department at a historically white state university in Savannah, Georgia, which was interesting, and we learned a lot about the Deep South while there. And I practiced criminal law in a public defender's office in rural South Georgia. And I learned a lot practicing here in Iowa for 5, 6, 7 years before that. I learned a hell of a lot in my less than a year in Georgia. Very different experience, and a lot of the issues that you hear about, that we see in the media about the criminal justice system, were really highlighted for me in Georgia. And then came back here in 2006, and I started working at the law school, and I've been there since. So I like to start by talking about our criminal justice system. This is a photo of the federal courthouse in Davenport, so an hour from here, the U.S. District Court. And I don't know what the experience is for college students today, but I have a sense of I think, kind of our societal expectations, the cultural assumptions that we make. And for a lot of people, and probably especially people who look like me and Andy, you're raised with this sense that we live in this great country and we have the best justice system on earth. We have the jury system, which is the protector of our rights. We have all of these wonderful constitutional protections, and the U.S. Supreme Court is always there to make sure that everyone has their rights respected, that we are applying the law in the right way. And we focus a lot in our system on our procedures. We kind of have gotten to this point where we think about all of these procedural hurdles, these procedural safeguards, the right to this, the right to that, the right to an attorney, the right to not incriminate oneself, that we think about all of these rights, all of these procedural hoops that we jump through as assurances that we get it right, okay? And so most of American history, we have looked at our criminal justice system, and we've looked at the rights we enjoy, we look at all these protections, all these procedures, and we've equated those with, we must get it right. And again, I think that people, especially our generation, especially white guys, probably, you were just instilled with this vision that the criminal justice system gets it wrong. And when it doesn't get it wrong, it's kind of obvious why. We look at the 1950s, the 1960s, ideology during the Red Scare, the Cold War, or the terrible racist legacy of the southern United States, when we know people were unjustly convicted of crimes they didn't commit, but you could kind of make sense of it. You could kind of say, okay, this time, this place, here's why that happened. That's not system-wide. That's not something that happens to everyone. And at the same time, you would hear people say, before 1990, before 2000, you would hear people say, I didn't do it. They convicted me of a crime I didn't commit. And by and large, those types of protestations were dismissed. We looked around and we said, yeah, you did, because we gave you a lawyer, and we gave you a fair trial, and we gave you a jury, and we gave you the right to discovery, and we gave you all of these procedural protections that a person is entitled to. And so, by going through our constitutionally protected criminal justice system, we know that you must have committed this crime, that you are the actual perpetrator. And so those situations where we knew that we had the wrong person were kind of egregious situations. And there's a case from Nebraska that my students read to start our wrongful convictions course, where a man is convicted of the murder of his best friend. They'd gone off on the Oregon Trail, I think literally on the Oregon Trail, and the friend comes back without the other guy, with some of his stuff. They later discover a skeleton in the desert. They presume that he must have killed his friend, taken all his stuff. Finally track the guy down, convict him. He has his appeal. He goes through his procedures in the Nebraska Supreme Court. He's convicted, it's affirmed, and he's executed. He's condemned to death and hanged. About 5 years later, his friend walks back into town, very much alive. The murder victim is alive. And so we had those stories, these extreme situations where it turns out the murder victim is alive. Okay, so we know we got it wrong there. But we didn't think this was a common thing. We thought that it was pretty rare that we would convict an innocent person of a crime. And part of the reason behind that was we didn't have a way to know. If somebody said, I didn't do it, we kind of looked back, we said, well, you had all the procedures, and there was an eyewitness, and we had a statement, or we had a confession, and we have some physical evidence that matched, and we added it up and said, you must have done it. And the game changer was this, deoxyribonucleic acid, which I don't know a lot about. I'm not a DNA expert, but I suspect you've all heard of DNA, and I suspect you all know that it's this fancy, science-y, basic hereditary material in all of us. And as DNA technology was developed in the 1980s, people realized that it provided a much higher level of individual identification than anything we had used in the past. And so before DNA, in a criminal setting, when we were looking to match a perpetrator with a crime scene or a crime victim, we would look at things like blood type. We would look at things like fabric or hair left behind. Sometimes we'd be able to look at fingerprints. But most of these things were matching games, okay? They weren't science where we had a high level of, we know this came from this person. It was more a matter of, well, we found this hair at the scene, and it sort of looks like your hair. Or we found this piece of fabric at the scene, and it sort of looks like the piece of fabric from a piece of clothing that you were wearing. Or even fingerprints. Our analyst assesses that based on the matching points that we're using, that this fingerprint probably came from this person. But all those things, it turns out, were fallible. So DNA comes along, developed in the laboratory for scientific purposes, and people start to realize that it can be used in criminal identification process as well. And it's a great tool for identifying a perpetrator. Because unlike all these other techniques, which were sort of matching, this thing looks like this thing, and we add enough of those together, probably you're the person who did it. Unlike that, DNA has about a 99%, higher than 99% rate of certainty when matching a sample with an individual. Okay? So if we find skin, blood, semen, whatever, at the scene of a crime, we can test that, we can test the person, and we can say, yes, we are 99.9 at least % confident that this sample came from this person. But the really amazing thing about DNA, and the thing that made it so important to the Innocence movement, was that it has a 100% exclusion rate. And so if you have a good sample, and if you do good testing, you can say with 100% certainty, this sample did not come from this person. We know that, we've scientifically proven that, and there's no question about it. And that was kind of a game changer. Because think about all these people who had said, I'm innocent. I know that there was a hair that looked like mine left at the scene. I know that somebody says they saw somebody with my description running away from there. I know that I don't have a good alibi that time. I know that I have a criminal record. All these things that added up to conviction plus all the procedures we put you through. Now they had this tool that could definitively prove that they didn't commit a crime. And so a couple of lawyers start familiarizing themselves with DNA and realize that they can apply it to these old cases to investigate people who claimed that they'd not committed crimes. And they started doing that late 1980s, early 1990s. Two guys, Peter Scheck and Barry Neufeld in New York, established the Innocence Project in the early 1990s with the goal of looking at old cases where people had claimed innocence, used DNA technology to determine whether the person actually had committed the crime or not. And they discovered that much more often than we thought, not to say millions of cases, initially dozens of cases, but much more common than we thought, people were actually convicted of crimes they didn't commit. Innocent people were in jail, in prison, for things that they hadn't done. And so they realized that there was this opportunity to review cases and start to use this technology to exonerate people unjustly convicted of crimes they didn't commit. Now, a couple of caveats. So this great tool, wonderful, good initiative, but a couple of caveats. First of all, you have to have DNA to use DNA testing. And think about the wide range of criminal cases out there. Think about the things that people do to commit crimes. A lot of them don't involve leaving blood, tissue, bodily fluid at the scene of the crime. If somebody were to walk in from the back of the room and shoot me right now, DNA might be irrelevant in terms of identifying that perpetrator, right? A lot of other crimes, robbery, burglary, a lot of categories of crime, DNA is not going to be terribly relevant. We also have to keep in mind that even where DNA is going to be useful, which is often crimes such as murder and sexual assault, even where it is going to be useful, we have to have it well preserved. And we have to do the testing extremely well. And so that means that going back looking at these cases, a lot of times what happened is these lawyers who were reviewing old cases discovered, yes, this was a claim of, this person was convicted of sexual assault, this person was convicted of murder. There was biological evidence involved, but 10 years later, it's not around, or it hasn't been preserved, and it's no longer testable. We can't use it anymore. So, to date, and this number just went up last week, there have been 341 DNA exonerations in the U.S. So since the early 1990s, 341 people convicted of crimes that they did not commit, and we absolutely 100% know they did not commit the crime because DNA has told us that the evidence used originally to convict them did not match to them. Out of those, they served an average of 14 years in prison. So we're not talking about mistakes that were immediately corrected in a lot of cases. Very often we're talking about people who sat in prison for a decade and a half, 2 decades before they were released. About 20 of those people were on death row. They were awaiting execution before somebody went back and said, turns out they didn't actually commit that crime. You see here another stat that I think is interesting. Almost half of those cases didn't just lead to somebody getting out of prison, it also led to identifying the real perpetrator. And keep in mind, when we talk about wrongful convictions, when we talk about convicting an innocent person, we usually think about the injustice to that person. Like, that's terrible that 341 people spent an average of 14 years in prison. But that also means that in 341 cases, maybe there were some co-defendants, maybe 300 cases, the actual perpetrator went unpunished. And the actual rapist, murderer, remained on the streets. There was a public safety issue as well. So almost half the cases, the exoneration also led to the identification of the actual perpetrator. Now again, this is this small subset of cases where DNA evidence was available for testing and where biological evidence was involved in the case at all. So we kind of extrapolate out from that. A lot of people have done research on this to try to figure out how many cases really are there of people convicted of crimes they didn't commit. Because if there are 341, those are the ones where they left DNA, that DNA was maintained and testable, and somebody took the time to actually test it. That's a pretty small subset of all the crimes out there. So people say it's at least 10 times, perhaps, that number, if not more, that we're talking about thousands of people in the U.S. criminal justice system who've been convicted of crimes that they didn't commit, that DNA potentially could prove their innocence. But there's also a larger category of crimes that don't involve DNA. And there's a relatively new project, about 2 years old, by the University of Michigan Law School, trying to document other cases where people were convicted of crimes they didn't commit, but not necessarily involving or not exclusively involving DNA. So they're trying to compile cases where somebody was convicted of a crime, and later it turns out that the victim came and said, I lied, that wasn't the real perpetrator. Or where we discovered that other evidence that was used, such as bad hair comparison technology or bad firearms testing, led to the conviction of somebody and that they were actually determined to be innocent. And so we're at almost 1,800 cases across the United States, both DNA and non-DNA cases of people convicted of crimes they did not commit. To date, only 12 of those have been in Iowa. None of those have been DNA cases. And I think that there are potentially 2 explanations for this. This is something that we talk about a lot. Our project talks about. Part of this might be the fact that we haven't looked as often. We haven't had the resources to review cases the way that other states have. We haven't had the egregious problems that have led people to put the resources into this type of review. The other thing, though, I think is maybe we have fewer of the underlying systemic problems in Iowa. We tend to have more uniformity in terms of training law enforcement. We have I think most people would agree, really good crime lab in the state of Iowa that has people have a high degree of confidence in. We have judges who are not elected in popular elections. They're merit-based selections. So there are a lot of factors, I think, that reduce the pressures that would lead to wrongful convictions as they exist elsewhere. So wrongful convictions happen. 341 people have been let out of prison due to DNA testing. Good for them. We have sort of fixed the wrong for them. We've tracked down the actual perpetrator. But another part of this that the folks involved in this initiative realized pretty quickly was that this effort wasn't just about remedying wrongful convictions of individuals, but also that they were getting this interesting insight into what was going wrong with the system. So that each of these 341 people exonerated through DNA evidence, as each of them was released, we have another case study to look and see what went wrong in the U.S. criminal justice system that led to that person being convicted. So sort of this evidence-based opportunity for criminal justice reform. And for me, this has been one of the really interesting parts of this, because it's allowed us to look at this case set and say, what can we do to improve the functioning of the system to reduce the likelihood that innocent people will be convicted going forward, and to ensure that we have a high degree of confidence in criminal convictions. And so of those 341 DNA exonerations, these are the 6 most common factors. These are, if you go through and sort of detail the checklist of what happened in each of these cases, these are the 6 top vote getters. And often, more than one of them were occurring at the same time. So eyewitness misidentification, bad science or badly applied science, false confessions, snitches or incentivized witnesses, government misconduct, prosecutors or law enforcement misconduct, or bad defense attorneys. So these are the main categories. And those bottom 2, government misconduct and bad lawyering, are present in a lot of cases, so we haven't tracked, it's been harder to track just how often they complicate these other factors. So this data is several months ago when there were only 321 exonerations, but this shows you the frequency of each of these contributing factors. And as you'll see, of those first 321 DNA exonerations, almost 3/4 of them involved a mistaken eyewitness. About 1/3 of them involved false confessions, and about half of them involved bad science or badly applied science. I'll talk about each of these briefly. I think that these are fascinating because they bring in aspects of sociology, social psychology, law, really some interesting case studies here. And those of you who have interest in this, I encourage you to read more, dig more deeply into these. The first is eyewitness identification. Again, 3/4 of those DNA exonerations, people who we know did not commit the crime, 3/4 of the time, there was a witness on the stand who pointed at the defense table and said, I saw that person commit this crime. 75%. And they were wrong. And so what this reveals is we have always had high confidence in eyewitness identification. Intuitively, we think, I saw it, therefore it must have happened. And this has been eye-opening to realize how often eyewitnesses get it wrong. Some of you, I'm sure, have taken psychology classes where you've learned about this phenomenon of mistaken eyewitness identification. But there are these sort of 2 places that this happens. One of them is the eyewitness themselves. What happens with our mind? What happens with our biology? We see a lot less than we think we do. We're influenced by other factors, cross-racial identification, weapon focus. Everybody thinks that they're much more observant when they're in a time of crisis. They're not. Their attention is much less focused. People have a hard time processing memories. Those memories can be manipulated. We compartmentalize things when we recall them. We can add facts. All of this happens within the mind and the eyes of the eyewitness. So those are all things that are estimator variables going on with the individual. But then we also have these system variables, things that investigators can influence. The way they ask questions, the way they conduct an investigation, the way that they preserve or approach eyewitness evidence. So I'm going to ask, a little experiment, and some of you will have done this in a psychology class, I'm sure, before, but let's have the people on the sides close your eyes, okay? So those on this side, those on that side, close your eyes for a few seconds here. Those people in the middle, you see the Ronald Reagan character here, correct? Okay. And you still see Ronald Reagan, a little bit blurry, but you still see him, correct? Okay? Fair enough. Close your eyes. Other folks, open your eyes. Sorry, just gave it away. People in the middle, keep your eyes closed. You see the woman here, correct? Okay? And she's going to be a bit blurred, but you still see the woman, right? Okay. So, everybody open your eyes. Simple experiment. But people on the side started with the right image. People on the left started with the center image. You both then saw the middle images. But it's priming. I'm telling you, here's what you're going to expect to see. Or you've looked at one thing, and now you see a second piece of that, you see a variation of that, you assume that it's connected to the first thing. So a very simple exercise in how I, as a questioner, as the presenter of the information, can impact your interpretation of that middle image. And again, imperfect, kind of a little trick here, but I suspect for a lot of you in the middle, you would not have looked at this image and said, oh, that's a woman, right? And those of you on the sides, you would not have looked at that middle image and said, oh, that's Ronald Reagan, but for having me said it earlier. So you see what happens there. Same thing with these images. We're looking through a six-pack, a collection of photos, lineups. I, the investigator, I, of course, get to assemble these. I pick which 6 photos or which 20 photos you're going to look at. And let's say I lay these 3 in front of you, and I happen to mention that another witness remarked that it was a light-skinned black man who committed this crime. Who are you going to be drawn to if you view this as kind of a multiple choice test? A, B, or C? Okay, so these are the photos I select. I let slip light-skinned. You might be drawn, based on that, you might be drawn more toward B, correct? All right. And what if I had happened to select these 3? Probably not B, right? So again, simple illustration, but what I do as an investigator, the way that I present you with information, the things that I let slip, the way that I frame a task, all are going to influence potentially what you do in terms of eyewitness identification. So let's say you're an eyewitness. You saw a crime from some distance. First of all, you're going to presume that I have the right person. If I've arrested somebody, you presume, well, sure, they got it right. Then we go through a photo lineup like this, and I have a lot of power to suggest which person you're going to pick based on the others who I select and the fact that I'm putting them in the selection. You think I know who the actual perpetrator is, especially if you know that I arrested somebody. You assume that I know who did it. And a lot of times when you present as 3 photos or 6 photos, I said earlier, multiple choice, you're not thinking, is this person the person or not? Is this person the person or not? You're doing comparisons. And you're saying which of these 3 looks the most like the person who I think I saw. So we go through this. You pick the person who maybe I subtly, intentionally, or unintentionally suggest. And let's say at that point I give you a pat on the back and say, good job, that's who we thought it was. Okay, your confidence is going up, right? You picked a person who I had already selected. I've given you positive feedback. So now what happens when we go into a live lineup? Now you're seeing the person for the second time at least. Your memory of them is probably more based on the photograph than on the actual experience of seeing them. and you've had positive feedback about the photo that you identified. So we go through a live lineup. Yes, you identify the person again. Good job, that's who we thought it was. By the time you get into trial, your confidence is sky high. And you've seen this person multiple times, in person, in photos, all which may be very detached from the level of certainty that you had when the actual identification was made. So there's been a lot of research on this. Gary Wells at Iowa State University is one of the national, worldwide experts on eyewitness identification. Jennifer Dysert at John Jay School out of New York. They've done a lot of work on the psychology of this in terms of how people process eyewitness information or eyewitness experiences and the way that we can shape their recollection, the way that we can shape their experience in choosing somebody from a lineup. There's been research going on for about 20 years. Last year, a year and a half ago, the National Academy of Sciences released this major report kind of confirming all of this science and making recommendations, what we can do to improve the system. And so it says we need to do things like improving training for officers so that they're not making these mistakes. We want to have double-blind administration, meaning that if I'm the one presenting these pictures to you, I don't know who the suspect is. I can't give you subtle clues by tapping a picture. Or if you pick the wrong person, saying, no, don't rush. Take more time. Are you sure? We don't have to rush. I don't send you any subtle clues that are going to influence your selection. We standardize instructions for witnesses, and we document confidence at every stage. And again, this is important because if you give a description right after the person runs in here, shoots me, runs away, we want to know how certain are you at that point in time that it was this description, this height, this complexion, this clothing. Because that confidence could increase every step along the way. So we want to know at the start, how sure are you that this person did or didn't have facial hair? How sure are you sure that this person did or didn't have tattoos? And then we just need to do more research on all of this. Science. CSI has really influenced the criminal justice system over the last 15 years. This notion that we have analysts out there who plug stuff into computers and it tracks down the whole world and pops up a picture of the actual perpetrator. And it doesn't really happen that way. And a lot of times, the things that we were calling science, the things that we regarded as science in the criminal justice system, were not actually based on science. All of you at some point, middle school, high school, you learned the scientific method, right? Most of the things that we historically, classically have called science in the criminal justice system aren't actually science. They're really matters of, I think this thing looks like this thing. And even fingerprints, the way we started using fingerprints, it wasn't because there were researchers out there, it wasn't because there were scientists out there who did experiments and said, oh, look, we know that fingerprints can be matched, and here's the process we use to do that. No, it was a matter of a detective going into a courtroom and saying, here's something I found, and I'm pretty sure that this person's fingerprint looks like this print that I found. Nobody did research to determine what procedure minimized error. Nobody determined error rates. Nobody did research to say, here's what we need to do to conduct this comparison. And so these are just things that we called science. We kind of gave the sheen of science, but there wasn't a lot of science about them. So 2009, again, the National Academy of Sciences, this congressionally mandated organization, came out with a report talking about science in the criminal justice system, forensic science. And the results, this was meant to be kind of a study on what we need to do to better fund the system, how to improve it. And it ended up being this really scathing critique of our forensic science system in the United States. There's a federal judge from Washington, D.C. who presented this. He was the co-chair of the committee that looked into this. And he presented this and he said, we have a lack of scientific research on the validity and reliability of a lot of these disciplines that we're using in the courtroom. We don't have autonomous crime labs. We don't have accreditation. We don't have certification. we're falling short in a lot of ways. And the report itself included a couple statements that really are kind of shocking to think about. That this national congressionally mandated committee wrote, with the exception of DNA analysis, no forensic method, including fingerprints, has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. In other words, all these other things that we were using, this hair looks like this hair, this fiber looks like this fiber, I think this bullet came from this gun, I think this tire track must be this car, I think this shoe print came from the shoe. Those things really aren't science, including potentially even fingerprints. And I'll talk a little bit more about fingerprints. But just that generally we're calling things science that aren't. And these are all the things that the report looked at, all the categories that it looked at. Biological evidence, so things like blood testing, semen serology, controlled substances, fingerprints, pattern evidence, tool marks, fiber evidence, hair evidence, question documents, handwriting, paint, explosives, bite marks, and bloodstain patterns. That all these things we kind of accepted as science. We let analysts come into court and act as though they were scientists, and that really we weren't applying the scientific method in those cases. Nope. And so what the NAS report suggested is that we really need to start asking harder questions. We really need to train lawyers, law enforcement, judges to better understand science and to ask two questions in every case. Is this discipline that we're relying on actually science? Is it based on the scientific method? Is research vigorously being applied? Is there scholarship to support it? And then number two, is the analyst who is looking at this and making interpretations, are they unbiased? And are they following proper procedures? Because there are a lot of ways that analysts feel pressure to, you can help get this murderer off the street, but we need to know that this fingerprint came from him. A lot of times analysts, if they're not insulated from the law enforcement setting, can feel this pressure, or they feel like they're part of that team. They feel like they're on a side. And one of the things the report pointed out is science isn't supposed to be on a side. Science isn't meant to be partisan. Science is meant to be objective. Science is meant to be, sort of pure. And we should have it happening, we should have it operating in spaces outside of the investigation. We should insulate it from those factors. And I was going to mention fingerprints because I think most people would say, yes, fingerprints are valuable. They do allow us to match two things that we think are pretty individual, pretty highly individualized. But think about this. Nobody's ever actually done research. We always say no two fingerprints look alike, right? Just like snowflakes. Nobody's ever done research. There's not a peer-reviewed article out there to support the notion that no two fingerprints match. It's an assumption that we make. Maybe we're going to do the research now to support that. Nobody had ever determined an error rate for fingerprint comparisons. There were fingerprint analysts who walked into courtrooms 5 years ago, 6 years ago, 7 years ago, and said, we have a 0% error rate. I can tell you 100% that this fingerprint came from this individual. Well, no, you can't, because science requires you to do testing, and it requires you to determine procedures to use. And as it turns out, the procedures that people across the river in Illinois are using to make fingerprint matches may be very different from what we use here in Iowa in a particular department. The number of points that they're comparing, the process that they go through, the review, the quality assurance. None of those things are standardized, so we're moving in that direction with science. False confessions, and this is the last one that I'll talk about at any length, because I think this is in some ways one of the most fascinating. About a third of those 341 DNA exonerations have included false confessions. And when you look at law books from the early 20th century, they talk as though the notion of a person confessing to a crime they didn't commit is impossible. And it makes sense logically, right? Who would confess to a crime he or she didn't commit. Why would you do that? It's against your interest. Well, we know that it happens. We know that about 100 people who did not commit crimes, proven by DNA evidence, did confess to those crimes. And it turns out that this is a relatively common thing, and it has a lot to do with how we interrogate, how we question people. False confessions, there's this taxonomy developed by a guy named Saul Kassin, who's a famous social psychologist, and he sort of divides them into three categories. There are false confessions where a person voluntarily confesses. They have some other reason. They want to cover up something they did, so they confess to something that they didn't do. Or they're seeking notoriety. The Lindbergh baby, whenever that was, 1930s, there were hundreds of people who confessed to the crime. Obviously, hundreds of people didn't commit the crime. So there are times where people confess to crimes they didn't commit voluntarily. There's also a category called compliant coercive. And these are people who, in the interrogation room, at some point, make the decision that they're better off to just tell the investigator what they want to get out of that situation. So the short-term benefits outweigh, in their eyes, the long-term risks. And so think about this. You've been falsely accused of a murder, and you happen to be in Alabama. And I'm questioning you, and I'm telling you that you're going to face the death penalty for this crime, unless you come clean. Well, maybe after the second day of being in a small room with just me, maybe you're going to decide that, and what if I start telling you, we have footage, we have video footage showing that you were there. And your mother gave us a statement that she saw you commit this murder. We can lie in this country. There's no prohibition against law enforcement lying to an interviewee. What if I bring in a folder and put it on the table and say, this contains the DNA evidence showing that you were there. We have your DNA at the scene. We have you dead to rights, and you're going to the chair. Or the gurney, if they can find the drugs, I suppose. You're going to die for this, unless you want to confess. Might it at least cross your mind that you're better off to stay alive, confess to a crime you didn't commit, not go to trial? Maybe. And that's not even getting to the point of me putting any great coercive pressure on you, or me in any way mistreating you, or denying you food, denying you sleep, all these other things that can complicate the factor. But there's this third category that Saul Kassin identified, and I think this is fascinating. People who begin to internalize their false confession. People who begin to believe that they must have actually done it. And often these are people who have pre-existing mental, psychological disorders, but it's well documented that there are people who, after this type of coercive, pressure-filled questioning, begin to doubt themselves and begin to say, I must have done it. You have the evidence. I know I was there with her. I don't know how else it could have happened. Okay, I did it. And they will start to invent facts to support their confession. They'll give these detailed descriptions of what happened. So there's personal factors that play into this, mental health issues, psychological health issues. There are situational factors. The more confrontational that an interview is, the more likely that we're going to result in a false confession. And then investigative errors. There are a lot of things that I can do as an investigator to solicit a false confession. How many of you watched Making a Murderer? So, a good number of you. And what a great example. I don't know if Steve Avery and Brendan Dassey, I don't know if they committed this crime or not. I have my suspicions, and I especially have my suspicions with Brendan Dassey. But I'll tell you, the interrogation, his confession, is a great example of all the things that an investigator can do to contaminate a confession. Because what you see here is this young kid, what was he, 16 at the time, or 14? Young kid being questioned by two investigators, and he's just searching for whatever they want him to say. He's trying to figure out what is it that they're looking for, and he's offering things up. And if you remember this, they're asking him, so what did you do to her next? And he says, we cut her hair, because they make some reference to a scissors or a knife. We cut her hair. Is that what you're looking for? No, keep guessing. Eventually, we slit her throat, is what he comes up with on his third guess. But there are a lot of things that I, as an investigator, can do to contaminate your confession. And there are a lot of things I can do that give you facts that nobody would know except the true perpetrator. And if I start asking questions like that, and I start saying, no, that's not what you did, come clean. Nope, try again. No, you didn't cut her hair. What did you really do? And eventually you stumble onto, we slit her throat. What with? A knife? No, not with a knife. Razor blade? Yeah, a razor blade. Okay, so now what we have is maybe all you've said is, okay, yes, I did it. Now we go into this questioning where I start supplying information to you, but now we come out of the room with, he said he did it, he knows how she was killed, and he knows what weapon was used. And only the true perpetrator would know that. None of that was in the news. Only the person who was there would know that. I fed it all to you, but it comes out as, of course, it's an ironclad confession because only the true perpetrator would know these facts, and it's contaminated. I did that. I presented that to you. So really briefly, a number of the cases have involved incentivized witnesses, co-defendants, or snitches who are looking to reduce their sentence. This is something that obviously we need to improve. We need to avoid this type of situation where a cellmate is incentivized to testify against somebody. A lot of these cases involve somebody who either is solicited by law enforcement or on their own says, hey, I heard him talking in his sleep saying that he killed her. Great. We need that witness. We need that additional piece. We can cut 5 years off your sentence. And then, of course, both prosecutorial misconduct and law enforcement misconduct and bad defense attorneys only compound all of this. So we know what the problems are. We know what these factors are. We try to figure out how do we improve this. And that's another area where the social science research or the legal research helps us identify what we can do to improve the system through policy. So we improve eyewitness identification procedures. We do more scientific research on forensic science disciplines. We ensure that we record every interrogation. And I guarantee that if Brendan Dassey's conviction gets overturned, it's going to be primarily a fact of the fortunate fact that that interrogation was videotaped and that we have a record of what happened, and therefore we know how suggestive it was. Because if you just took his confession as a statement and you got rid of that videotape, it would be very, very difficult for him to challenge that conviction. So, Innocence Project of Iowa, we work with a project out of Kansas City, the Midwest Innocence Project, and our State Public Defender's Office. And we do basically two things. We try to review convictions in Iowa to provide assistance to people who have claimed that they've been convicted of a crime they didn't commit. And then we also try to work to improve policy. How can we work with law enforcement? How can we work with prosecutors, judges? How can we work with the legislature to remedy some of these problems through better eyewitness identification procedures by ensuring that all custodial interrogations are recorded? We have student volunteers in the College of Law. We have about 15 volunteers this semester who are working on case reviews, a couple who are working in a case that we're preparing for litigation, a case of a child death, where there's a lot of evidence suggesting that the person is not actually the real perpetrator or that there was no perpetrator, that the child was sick and died. But these are the types of things that we provide opportunities for law students to get engaged with. Hoping that this gives you kind of an overview of this topic. I mean, first of all, the fact that this happens, the fact that people are convicted of crimes that they did not commit. Secondarily, though, to learn a little bit more of why this happens and how important it is, I think, for us in society, those of us who are in the legal system, those of us who have connections to the legal system, to understand our responsibilities and what we can do to improve the system through better use of science, through better use of social science, through psychology, through a lot of this research that can help us do this in a better way. So I will leave it there and want to open it up, see what questions all of you have.
If anybody has a question from the back, I can come up with the microphone too.
What do you want to know about the criminal justice system?
You said you have 15 people working for you for your Innocence project, correct?
15 student volunteers,
15 student.
yeah.
Is that only graduate and law student, or is it?
Only law students at this point.
Okay.
Our partner organization in Missouri exclusively works with law students. So in the last year, we've not worked anymore with undergraduate volunteers as we had in the past due to their preferences.
Okay, thank you.
Good question for some of you guys. Looking at law school in the future, this might be a really interesting area to volunteer in. Certainly a little more interesting than torts and contracts and things, although those are important too.
Yeah, no, it is. It's a great way, I think, for students to understand the criminal justice system. And the students who are working in this are looking at cases start to finish. They're looking at police reports, they're looking at witness interviews, they're looking at trial transcripts, they're looking at what happened after trial and trying to piece all that together. And they're looking at the inconsistencies, looking for sort of the questions that appear in all that. And they know what these common factors are. And so they can sort of focus on those, try to see where potential problems may have occurred. Just out of curiosity, how many of you think about law school as a possible option in the future? A handful at least? Yeah. It's a fine route. As I said to somebody earlier, you want to be sure about it, you want to think it through, get some experiences to confirm that it's really the right interest for you. But it's a great career. How many of you listen to Serial, just out of curiosity? Only a few? So those of you who listen to Serial, do you think Adnan Syed is guilty or not? No
Yeah,
opinion?
kind of a maybe.
What about the making a murderer crowd? How many of you think Steve Avery is guilty? How many of you think he's innocent?
Got
More?
a few more on the innocent side.
Yeah, so people ask me that all the time, and I don't know whether he committed the crime or not. What I do know is both of those series have been really useful in that they've shown the complexity of this. They've shown just how messy the criminal justice system is. And I think a lot of us go into it or go about our lives thinking that it's pretty clear-cut and we have a high degree of confidence and we have procedures that ensure that we know whether a person did this or not. And I think very often the way that it turns out is it's kind of guesswork. And even when everybody's well-intentioned, even when you have prosecutors, law enforcement, defense attorneys, judges, jurors trying to do the right thing, a lot of times it's not 100%. A lot of times we are going back and we're using imperfect procedures to try to recreate or understand what happened in the past. And a lot of times we don't know, and we can't know exactly what happened. It's a best reassembly. It's a best guess based on a lot of information, but it's not the 100%, I think, very often that we think it should be or that we want it to be.
I had a question for you, Brian, and we talked about this before, but one of the scenes that I show in class here from Making a Murderer is when Steve Avery goes on the record saying he's not going to testify at his own trial. And so we talked about this earlier in the semester. Brian's tried a lot of criminal cases. I've tried just a couple. And what would be the reasons that somebody would or wouldn't testify at their own trial? And what do you think the dangers of that or the benefits could be?
Yeah, so when a person chooses, a person has a constitutional right not to testify, and there is a rule that can't be inferred as a presumption of guilt. So if you're charged with a crime and you say, nope, not going to testify, that can't be used as any kind of evidence to suggest that you did it. Now, whether jurors respect that is another story. A lot of times the presumption of innocence, I think it's tough to ensure that jurors are honoring. But at least legally, that can't be taken as an inference that you actually committed the crime and don't want to talk about it. But when you choose to take the stand, you are first of all opening yourself up to not just telling your story, your side of it, but you're also opening yourself up to cross-examination by the other side, by the prosecution. And that means that you are going to get beat up, that you are going to have hard questions asked, that you are going to be doubted, that you are going to have bad things in your life brought up. And I think a lot of times defendants and attorneys have to think, is my client going to come across good given that situation, even though he or she didn't commit the crime? Like, is that type of questioning, is it going to be so sort of make things look suspicious? Are they going to be questioned in a way that, makes them seem defensive, makes them seem not forthcoming, in a way that's going to do them more damage than good? I think there's also always the fact of weighing how much good can a person do. Because for a criminal defendant to get on the stand and say, I didn't do it, is that persuasive to a juror who knows they were arrested for this crime, they've been in jail for this crime, they're here in an orange jumpsuit, there's all this evidence we just heard? Real easy for him to say he didn't do it. Real easy for him to say I was somewhere else at this time. So in some ways, even though you're the best witness, you're the one person who knows what really happened, there's also a lot of skepticism about your credibility. And I think a lot of times a defendant, there's this assumption that their testimony is going to be dismissed or it's going to be marginalized by a jury simply because it comes across as self-serving. You didn't commit the crime? Great, but it always looks convenient for you to say you didn't commit the crime even when you didn't do it. And the third piece is that every witness can be impeached, their honesty can be challenged, and so if you have anything in your past, any criminal convictions, perhaps even disciplinary proceedings as a student, could be brought up as evidence that you have been dishonest, you've been distruthful in the past. And now, okay, not only is it self-serving for you to stand up and say, I didn't do it, but now the prosecution has also provided evidence that not just are you saying you didn't do it, how convenient, but you're also a liar, you're a known liar. So a lot of reasons why it makes it very difficult for a person to take the stand in their own defense. A lot of times the ideal thing is to have another witness who's available who can testify to essentially the same facts, because it's just seen as not providing that much benefit and opening up to a lot of problems, a lot of questions.
Very interesting. Thank you. Any other questions for Brian before we wrap up? Yeah.
So the question is, do people who are exonerated from crimes they didn't commit, are they compensated? And it's kind of an imperfect system, and like most things in our country, it varies from state to state. So there are some states, like Iowa, where if you can prove, and it has to be kind of a high burden to prove that you didn't commit the crime and you didn't plead guilty and you had no part in bringing this on yourself, then you have a right to sue. And so you would bring a case against the state and you would ask a jury to determine how much you're owed. There are other states, Texas, for example. Texas has actually very good wrongful conviction laws. Part of it is because a lot of those 341 people who've been exonerated using DNA have been from Texas, so they recognize they have the problem. There's been some urgency in remedying their system. But Texas has, and other states, have a formula. And so for every day or every year that you spend in prison, you're entitled to X amount of compensation. And there are other states that don't have any compensation scheme. And so that means that, yes, maybe a person can go out and sue, but there's no law that provides for that. Iowa has a law that says if you prove this, you can sue for compensation. Texas has a law that says if you prove this, you get X amount of money. There are other states where you just kind of have to hope that you'll be able to win a case, or hope that the legislature will look at your individual case and say, yes, we should compensate this poor person for this crime. It goes beyond money, though, because you're looking at people who've had 14, 18, 20 years of their life taken away. So you have people who have health care issues. You have people who have educational deficit. You have a lot of mental health issues, often which led to them being wrongfully convicted in the first place. And you have people who, they've never seen a cell phone. They're coming out from a different era. And so sort of this reintegration compensation, there's a monetary part of it, but then there's also this sort of reintegration into society, support to get a job. And for better or for worse, a lot of places ask, have you ever been accused of or convicted of a crime? You're a poor, wrongfully convicted person, exonerated after spending time in jail for something you didn't do, and you have to mark on your application form, yes, I've been arrested for a crime. Makes it tough for you to get that, or it's going to raise suspicion about you getting that job. People know that you've been in prison, even though you have your certificate saying, I didn't do it. So there's a lot of challenges, and it goes beyond simply the money. Other question? Is the Madrid bombing the one where they got the lawyer from Washington State or something? Like they got an American who had no connection and arrested him in connection with this, and it turns out that it was, and yeah, there are those situations. And a lot of times what it is they have a partial print. They have less than a good print. They're trying their best to make a comparison, but we don't have this sort of research protocol to say, here's how good of a print you have to have, and here's what you need to do to make a comparison. Here's what we need to do to review and assure that that's a good match. And even then, we don't know that we can't make a mistake. When we say, okay, we have a pretty good developed print and we're doing a 9-point comparison, we still don't know that we can't get it wrong, and we don't know how often we do get it wrong. So certainly it happens. So fingerprints, I don't want to suggest aren't useful, but I think there's a recognition that we haven't been using them as well as we should. We need to make the use much more scientific and sort of move it forward from there. Anything else?
Thank you very much, Dr. Farrell.
My pleasure. Thank you all.
All right, we'll see you guys on Thursday for exam review. Have a good day.
Yay.
Yay, exam.